happy to have all of you here today. I have a few remarks to make or in fact, some extensive remarks to make on this particular issue. Earlier this month, the mislabeled Employee Free Choice Act of 2009, S-560, was introduced in both houses of Congress. The bill is identical to the bill introduced in the last Congress, including its name. I would have thought that at least the name would change. Free choice? Give me a break. We are living in a land of make-believe where our words have the opposite effect of their true meaning, much like Humpty Dumpty, who said that, quote, words mean only what I choose them to mean, neither more nor less, unquote. If properly labeled, the bill should be called the Employee No Choice Act or even the Employee Forced Coercion Act of 2009. Not only is S-560 a misnomer, it does not have the support it had in the last Congress. This year's bill was introduced by a smaller number of Senate Democrats than in the last Congress, 39 co-sponsors this year versus 46 last year, and in a year where there are more Senate Democrats in Congress to support the bill. And we understand that there are a number of Democrats who voted for cloture in the bill last year who are having real reservations about supporting the bill this year because of what the bill, regardless of its name, would do in today's troubled economy. Plus, this year, there's no White House veto threat. Shortly before the bill was introduced, the Senate Health, Education, Labor, and Pensions, the HELP Committee, quickly conducted a hearing that many of us were unable to attend. In an unusually raucous atmosphere that included several hundred boisterous union members, the hearing produced a lot of heat but shed very little light on what is the most radical overhaul of national labor policy in my 30 years in the United States Senate. Well, today's hearing will shine the light on S-560 and will do so in a much less heated environment and in a much more analytical fashion. At the HELP Committee hearing, Senator Harkin called for a reduction in the decibel level and perhaps mentioned, quote, compromise, unquote, as a more rational way to discuss EFCA. If it's some type of compromise on EFCA that Senator Harkin is suggesting, then as long as we are discussing EFCA and evaluating its true impact, I don't see any possible compromise. Nor do I think either organized labor or the business community is willing to discuss any, quote, compromise, unquote. EFCA is not just another bill that can be passed quietly outside the public eye or that can be, quote, compromised, unquote, with a few minor tweaks. It represents a sea change in labor management relations that has developed since the 1930s. Over the weekend, a group of 3 large companies hosted a press conference to announce that they had come up with a, quote, third way, unquote, to revise national labor policy. Now, I don't want to give this group more credence than that group deserves, but regardless of semantics, third way or compromise, it has been rejected by both organized labor and business as a non-starter. But there are some interesting revelations at the press conference that show why EFCA is in trouble. The press conference was led by Lanny Davis, former senior staffer for President Bill Clinton and a self-described liberal pro-union Democrat. He confirmed what we've all been saying. EFCA would effectively deny workers a secret ballot vote on the question of union representation, and there is no choice for workers to make in the matter. He described the secret ballot as, quote, a bedrock principle, unquote, in our nation's history and a principle that cannot be compromised, unquote. Now, my colleagues who are here with us today and I disagree, and so do many others. So do liberal former Democrat Senator George McGovern and Reverend Al Sharpton. Davis further described first contract interest arbitration as contrary to the democratic principles of President Franklin Delano Roosevelt and Democratic Senator Robert Wagner, the author of the Wagner Act. My colleagues and I agree this bill is anti-democratic, both with a small d and with a large d, which is why it came as no surprise when Lanny Davis said that in visits to 20 Senate offices, quote, I didn't get a single one that didn't bless me, unquote. If anything, the one thing this proves is that EFCA is in real trouble. And I would say it's un-American, and there is no compromise. Now, during the HELP Committee hearing, Senator Harkin ridiculed business for describing the battle over EFCA as Armageddon. Well, it sure seems like Armageddon to me based on the bill's anti-democratic principles. the bill's monumental changes to more than 60 years of national labor policy, denying workers a private secret ballot in a democratic process on whether to be represented by a labor union, and compulsory outside interference by the federal government in setting terms and conditions of employment, and I might add even wages, for private sector workers and businesses. Now, with regard to compulsory first contract arbitration, what would occur if someone from the federal government came into a family-owned business, or any size business for that matter, and said, this is what you must pay your employees? These are the benefits you must provide. And by the way, you must become part of your industry's multi-employer pension plan that is badly underfunded, and you must accept your industry's pattern bargaining agreements. This is your work schedule and the hours you employees will work. These are your work rules. This is your disciplinary procedure. And oh, by the way, you may not subcontract work. Any new operations must be union. You must remain neutral in union organizing campaigns at other facilities, and you must check off dues for the union from employees' wages. This is not just for the first contract. All future, quote, collective bargaining agreements, unquote, will be subject to compulsory binding arbitration. Job security for the arbitrator. Finally, you are not entitled to challenge my award, and it's final and binding for 2 years. And to add insult to injury, employees will be denied the right to vote on whether to accept the arbitrator's agreement. Let's say the arbitrator is not familiar with your business, your industry, your competition, your community. Let's say the arbitrator just plain gets it wrong. Let's say that the wages, benefits, and work rules you're mandated to provide make your company non-competitive. I wonder if Senator Harkin thinks that might trigger Armageddon against those federal bureaucrats who cram the terms and conditions of employment down the throats of these employees. Will it trigger Armageddon against members of Congress who are responsible for the Employee Free Choice Act? You think the public's anger and frustration over the bank bonuses is bad? Just wait until you see the Armageddon that would erupt after EFCA's first contract interest arbitration award. The first takes away workers' rights to a secret ballot election and then crams terms and conditions of employment down their throats by the feds. These are fighting words. It's precisely the result that FDR and Bob Wagner sought to avoid in the New Deal Congress. The term compulsory first interest arbitration. Does anyone realize what that means? The word arbitration sounds good, doesn't it? Helping people reach agreement, is that what arbitration does? No, that's conciliation and mediation. It is not grievance arbitration either. No, that's where the arbitrator interprets the terms of an existing collective bargaining agreement which has been freely negotiated by labor and management, but when the parties disagree as to how the contract should be interpreted. Interest arbitration is where the arbitrator actually writes the contract based on what the arbitrator believes would have been and should have been the terms of the contract if the parties had agreed. There is no contract, no meeting of the minds. It is a substitute for the parties negotiating and agreeing to a contract. It is the antithesis of free collective bargaining. It is what the liberal New Deal Congress sought to avoid when it wrote the Wagner Act to begin with, having the federal government involved in setting the terms of employment. They wanted to avoid that. It's what the Supreme Court based its 1937 decision on in upholding the constitutionality of the original Wagner Act, although by a 5-4 margin, in the Jones and Laughlin Steele decision. EFCA throws all that out the window. Under EFCA, after 120 days of bargaining for a first contract, which may have been in complete good faith, that is, good faith bargaining with no allegation that either party, labor or management, was in violation of sections 8A5 or 8B3 of the National Labor Relations Act, or refusing to bargain in good faith. And let me be even clearer. When no one has done anything wrong in the bargaining, and where the parties may not even be at impasse in the negotiations, after 120 days of bargaining, EFCA mandates that a federal arbitrator will step in to write the terms and conditions of employment for the business and its employees. And that is simply wrong. It's bad labor policy, as the New Deal Congress believed, because it discourages true collective bargaining when the union knows that it can guarantee a contract and perhaps avoid taking responsibility for failing to negotiate its overly ambitious promises to workers when convincing them to sign a card. It's bad economic policy, especially under current economic conditions. Noted economist Dr. Ann Lane Farrar has predicted that for every 3 points increase in union density under EFCA, the next year there will be a 1% increase or 1 point increase in unemployment. In other words, if union membership increases by 1.5 new members as a result of EFCA, which is the prediction of the SEIU President Anna Berger, for the Service Employees International Union alone, there will be a loss of 600,000 jobs. That's totally contrary to President Obama's desire to increase employment, and it may be unconstitutional. As long as compulsory first contract interest arbitration is in the bill, I don't know how anybody could talk compromise. And that's really what they're after, almost more than anything else. Denial of secret ballot elections. Think about it. We have all heard and read a lot about EFCA's card check certification. But now let's get one thing straight. Some are saying that EFCA does not eliminate a secret ballot election. You've seen the ads yourselves. That it gives workers a choice between card check and secret ballots. Who are they kidding? Let me read the language of the bill to you slowly and carefully. S-560 provides at Section 2, streamlining union certification. 6, notwithstanding any other provision of this section, whenever a petition shall have been filed by an employee or group of employees or any individual or labor organization acting in their behalf alleging that a majority of employees in a unit appropriate for the purposes of collective bargaining wish to be represented by an individual or labor organization for such purposes, the board shall investigate the petition. If the board finds that a majority of the employees in a union appropriate for bargaining have signed valid authorizations designating the individual or labor organization specified in the petition as their bargaining representative, and that no other individual or labor organization is currently certified or recognized as the exclusive representative of any of the employees in the unit, the board shall not direct an election but shall certify the individual or labor organization as the representative described in subsection A. Now, in case you did not hear that, the National Labor Relations Board is prohibited by law from conducting a secret ballot election under S-560. Even if the employees won an NLRB supervised election, it would be unlawful to conduct a secret ballot election. Now, sure, if the union only has the support of a small minority of the employees, let's say only 30% of the employees sign cards, it can still seek an election, but give me a break. That just does not occur as a practical matter under current law. And no union would seek an election if it only has a minority of employees supporting it. Under EFCA, a union would never seek an election if the union only needs 50% plus one employee to demand automatic certification without an election, even if the employees wanted a secret ballot election. And that would be the result even where the union had promised a secret ballot election while soliciting signed union authorization cards. I may have been born at night, but I wasn't born last night. It has been said that employees can refuse to sign a card and demand a secret ballot election, or only sign a card if it is in support of a secret ballot election. Under EFCA, guess again. If a union organizer is successful in getting 50% plus one of the cards signed, the union will take the cards to the NLRB for automatic certification without, got that word? Without an election. And let me give a very clear example of why the denial of a secret ballot election is unfair. Under current law, everyone in the collective bargaining unit has the opportunity to vote for or against the union. Now let's assume that this room is equally divided. Those 100 people sitting on the left side all want the union. Those 100 people sitting on the right side all oppose the union, and I am the tiebreaker. Under current law, everyone in the room has the right to vote, even those opposing the union. Here's the big difference. Under EFCA, once the union organizer gets those sitting on the left side of the room to sign union authorization cards, and one more person is hoodwinked or otherwise coerced, or for any other reason signs a card in support of the union, the organizer does not have to ask those sitting on the right side even to sign a card. They are automatically in the union and a part of the bargaining unit regardless of whether or not they were asked to sign cards or whether or not they even knew there was a union organizing drive. That's different from the concept of exclusive representation under the current secret ballot process, where everyone at least has the right to vote on this important issue. Now, EFCA is simply wrong at the wrong time for this country. Economists tell us it would lead to higher unemployment at a time when we are already hemorrhaging jobs. Businesses large and small tell us that it will make them non-competitive and force them to close their doors or move overseas. The American public in poll after poll opposes EFCA. For example, a January 2009 poll conducted by McLaughlin and Associates found that 74% of the public opposed giving up the right to vote in a secret ballot election for a, quote, card check, unquote, process. Interestingly, 74% of union households also opposed, quote, card check, unquote. In an even more recent March 19th Rasmussen poll by a margin of 56% to 14%, non-union workers believe that most workers do not want to join a union. As for their personal preference, only 9% of non-union workers wanted to join a union themselves, even if they are worried about losing their jobs in the near future. 81% would not want to join a union. They oppose losing the secret ballot election to determine whether they want a union. They oppose having their wages, benefits, and other terms of employment dictated by a federal arbitrator, especially when they have no right to ratify or approve those terms. And they are opposed to joining a union. All of this is, in fact, Armageddon for our private free enterprise economy. It puts us on the road to European-style system of economic socialism and rigidity. The Employee Free Choice Act is not just a bad bill for labor management relations, it's an economically devastating bill for the country. Well, I know I've taken too long, and I apologize because we have great witnesses here today. But let's turn to the distinguished minority leader, and then Senator Bennett, and then Senator Rice.
Thank you, Senator Hatch. I think you covered it very well in laying out the case against this unfortunate legislation. I appreciate the opportunity to stop by and briefly recognize my constituent from Lexington, Kentucky, Kathy Gornick, who is president of Thiel Audio and is here on behalf of the Consumer Electronics Association. She's a past chair of the Consumer Electronics Association Board of Directors and is currently chair of CEA's Small Business Council and runs a successful business in Lexington, and I think will bring a unique insight into this particular issue, and I want to welcome her to town and thank her for coming. Thank you, Senator Hatch.
Well, thank you, Senators. Senator Bennett.
Thank you very much, Mr. Senator Hatch. There's really only one issue, and that is, what do employees want? If they want a union, they should be entitled to have a union. Equally, if they want to stay out of a union, they should be entitled to stay out of a union. And the question should be settled by a majority of the employees in a particular situation, voting in an informed and uncoerced circumstance. Now, for those who say that the present circumstances are stacked against the union, I would point out that when you have a secret ballot election, unions have won 68% of them, which means that by a 2/3, 2-to-1 circumstance, employees get what they want if they want a union. I have worked in a company that was unionized, and I've worked in a company that the unions tried to unionize, and I've worked in a company where the employees made it very clear they didn't want to have anything to do with the union. And each company is unique unto itself. Each company should be free, or the employees of each company should be free to make their own decisions. The thing that bothers me about this legislation is that it does not respond to the issue of what do employees want. It responds to the issue of what do union organizers want. And it is not true that union organizers' wants and employees' wants are always the same. And in the company in which I worked where there was a union, I saw, and we're going to hear from Frank Cannon, much more graphic examples than the things that I saw, where in order to keep pace within the workforce, employees would agree with the pro-union forces within their group as long as it didn't affect their secret ballot. Companies are in many instances like families because we spend most of our life there. We spend most of our time in direct contact with our fellow employees there. They become either our closest friends or sometimes our most burdensome pests in our lives, but we can't get away from them. We're there with them for 8 hours every day, 5 days a week, and sometimes longer. And when someone comes to you in that atmosphere where you're working with them closely and says, I want you to sign this union card, it's far easier to say, sure, I'll sign the card, knowing that the purpose of signing the card is to generate a process whereby there will be an educational campaign, the union speaking for so much, the employer speaking for so much, completely open and fair campaigning activity, and then a secret ballot. And if I'm an employee who does not want a union, I can sign the card and keep my fellow employees off my back, and then go into the private ballot booth and vote my convictions, and I haven't disturbed my personal relationships. I have seen personal relationships destroyed over these kinds of arguments in ways that are tragic to the individuals involved. So the consequences that I see coming out of this bill is that a union can start to organize, people can be pressured to sign cards without the employer even knowing the process is going on. And suddenly it is sprung, people have signed cards in order to maintain their personal relationship, perhaps thinking, not aware of the fact that this law is passed, that they could vote against it in a secret ballot, and discovering they can't. And there they are, trapped in a situation they would prefer not to have because we've taken away their right to vote in a secret ballot. Senator Hatch has already quoted the poll. 74% of union households do not want this legislation. So if we're going to respond to the basic issue of what do employees want, we're going to vote no and see that the legislation is defeated and thereby be true to the requests and desires of our constituents. Thank you, Mr. Chairman.
Thank you, Senator Bennett. Senator Risch.
Thank you very much, Senator. I want to thank Senator Hatch for holding this hearing and for your leadership on this issue that very easily could be one of the most important issues that this Congress will face. And I say that simply because we have in place in America laws that have governed union organization and collective bargaining for many years. We have a fair system and we have a level playing field. The relationship between an employer and an employee is extremely important. It is very important that there be a level playing field that dictates what the rules are for this relationship. We've had this in place for some time, and it has worked very well. Simply put, what we have in front of us is a bill that is unfair. It is a bill that unlevels the playing field, and it is a bill that overreaches. We don't need this in America today. We have stability between the employers and employees. That stability has been in place for a long time. It is governed by rules that have been in place for a long time, and those rules have been interpreted by court decisions. Having said that, if this bill passes, it would unbalance this important relationship, and that relationship between employers and employees, both groups of which are critical to the American economy, to our quality of life, and to our way of life. If that relationship is tipped one way or the other, it would be devastating to the American economy and to the American family. So with that, again, I want to thank you, Senator Hatch, for holding this important hearing.
Well, thank you, Senator. As you can see, I get a little worked up about it because I think this is really a very, very important issue or set of issues, and I just don't want the American people to be sold a bill of goods. But we're very pleased to have these four witnesses with us today. Eugene Scalia is a partner in the Washington, D.C. office of Gibson, Dunn, and Crutcher. He has served as solicitor of the U.S. Department of Labor. He's the author of more than 20 articles and papers on labor and employment and law, as well as constitutional law and other subjects. In 2006, he was named Regulatory Compliance Lawyer of the Year by Institutional Investors Compliance Reporter magazine, and he's also named top Washington, D.C. lawyer in employment litigation by the Washington Business Journal. In 2007, he was named one of the 50 top litigators in the country under age 45 by American Lawyer and one of the 500 leading lawyers in the country by Law Dragon. Frank Cannon is a foreman with C.J. Coakley Company, Inc., where he has worked since 1982. He started in 1962, or the company was started in 1962 by the Coakleys. The company became incorporated in Virginia in 1966, and today C.J. Coakley Company, Inc. is a complete interior contractor with a wide range of experience while constantly exhibiting a high degree of quality craftsmanship. Frank is from Maryland and currently resides in Huntington, Maryland. Augustine Martinez was named President and CEO of the United States Hispanic Chamber of Commerce in February 2008. Mr. Martinez served as Emmy Award-winning television executive for 30 years. He launched the network's first Spanish-language owned and operated television station in the tri-state Philadelphia market. Mr. Martinez's leadership in the industry has been recognized with numerous awards, including the Los Angeles Emmy Award for, quote, Best 30 News Broadcast, unquote. Mr. Martinez developed and managed community relations strategies with national organizations, including the Congressional Hispanic Caucus and the Congressional Hispanic Institute. Kathy Gornick is a co-founder and president of Theo Audio. She served on the Consumer Electronics Association Board of Industry Leaders and the Executive Board from 1995 to 2007. Ms. Gornick serves as chairman of the board of the Bluegrass Institute for Public Policy Solutions. She is also the first ever recipient of the Bastiat in Business Award presented in April of 2008. She has also been honored as a Kentucky Southern Indiana Entrepreneur of the Year. We are really delighted and blessed to have all of you here today. And if we can just go right across the table, we'll start with you, Mr. Scalia first, and we'll take all of your testimony before any questions. Each of you will be given 5 minutes. If you need a little bit more, we'll be liberal about it, but if you can keep your remarks confined to 5 minutes, it'd be helpful.
Senator Hatch and members of the committee, thank you for the opportunity to testify today regarding the Employee Free Choice Act, which would be the most far-reaching change in our labor laws in 60 years or more. I've submitted a written statement for the committee, and I will concentrate my remarks on the card check and mandatory arbitration provisions. As you know, the card check provision would require the National Labor Relations Board to certify a union without a secret ballot election if the union presented cards signed by a majority of employees stating they wished to be represented by the union. Currently, by contrast, an employer can ask a union to prove its majority support through a secret ballot election. Senator Hatch, as you emphasized, this card check provision would, in effect, eliminate secret ballot elections, and some EFCA supporters have suggested that while the secret ballot option would still remain and unions might use it, but as you say, as a practical matter, that will not happen, and secret ballot elections would no longer be a means by which union representation is sought. I'd like to make 2 points about the card check provision. First, supporters say they are proposing card check to stop intimidation in union elections. But the single best protection against intimidation in elections is the secret ballot. The Supreme Court has called the secret ballot, quote, the hard-won right to vote one's conscience without fear of retaliation, end quote. In truth, the effect of EFCA is not to eliminate intimidation in union elections. It's to give unions a monopoly on intimidation. Union members would confront employees in the parking lot, at their homes, at the local hardware store. Perhaps they would surround them. They would hand them a pen and an authorization card and ask them for their support. Voting that was once private, was by secret ballot, and was supervised by government officials would now be overseen by union organizers. Second point, in speaking about union elections, it's important to distinguish between employer coercion on the one hand and employer free speech on the other. Coercion is illegal under existing law. Employer speech, by contrast, that's non-coercive, is protected by the First Amendment, as the Supreme Court has recognized. As we'll hear in a moment, American jobs are created by entrepreneurs who've invested their time and their own energies in starting, establishing, and operating those businesses. And those entrepreneurs, under the Constitution, have a right to speak to the voters who will decide whether they must now share their enterprises with a union instead. Turning to mandatory arbitration, as has been said, the bill includes a provision that would authorize a federally appointed arbitrator to dictate the terms of a first collective bargaining agreement if the company and a new union that was certified under the card check provision could not reach agreement within 120 days. This provision has received less attention than card check, but I think it's arguably more destructive even of American business and the economy. As Senator Hatch, you said, one of the most basic principles of American labor law is that a company is required to bargain with a union in good faith, but it's not required to agree to any particular contract term. Justice Hugo Black, who was appointed by Franklin Roosevelt to the Supreme Court, said our labor policy has, quote, never been to allow government regulation of the terms and conditions of employment. Quote, it was recognized from the beginning that agreement might in some cases be impossible, and it was never intended the government would become a party to the negotiations and impose its views, end quotes. That's what we would have now. EFCA's arbitration provision would topple this pillar of American labor law. Companies and workers would be governed by so-called collective bargaining agreements that in fact are none of the above. They would not result from bargaining. They would not be agreements, they would be mandates, and they would not reflect the collective effort and view of the employees who would have no opportunity for a ratification vote. We should not turn the keys for managing American companies over to government appointees who themselves may not know the business and may have never run their own payroll. And Senator Hatch, as you emphasized in your remarks, a collective bargaining agreement does not simply establish what the wages and hours are going to be. It is the rule book for operating a company, which, as you say, can concern matters such as whether subcontracting will be permitted. It can concern things such as whether new technologies that save costs and reduce prices to consumers will be allowed. And again, as you mentioned, a collective bargaining agreement can determine such important matters as whether a company has to participate in a multi-employer pension plan, which is run in part by union officials and which often can be financially troubled, as we've seen. We do not ask judges to write our laws, and we should not trust government arbitrators to design the rules of operation for American business. Is that my 5 minutes?
Keep going. That's your 5 minutes, but you can keep going.
As I say, I've submitted a written statement, and I'll just refer the members of the committee to the last part of this statement where I talk about what I view as actually constitutional difficulties that this act presents. And those are, in brief, first, the Supreme Court has recognized time and again a constitutionally protected right to vote in certain circumstances. And it's been recognized by lower courts that that includes a right to secret ballot. I would argue that this act, given the enormous effects that it has on employees' lives, and given the state action involved through the government certification process, presents concerns under the First and 14th Amendment. And second, as I explained in my written statement, the Act also presents concerns under the Federal Due Process Clause because of the extraordinary intrusion that it makes upon employers' ability to manage their own property that's the result, again, of their investment and their efforts. Thank you very much for your time.
Well, thank you, Mr. Scalia. We really appreciate your comments. Mr. Cannon, you're next.
Thank you, Mr. Chairman and members of the conference, for letting me have the opportunity.
Press that button in front of you if it doesn't
For
show.
letting me have the opportunity.
Appreciate it.
Thank you, gentlemen. To talk about my experiences as a worker confronted with harassment and intimidation as a part of an organized union campaign. In this card check system, I believe that workers could be bullied or misled into voting yes for this. I've seen efforts to mislead my fellow workers, myself, tricking people into doing what the union wants. I've worked with Coakley since 1982, and then worked in all kind of commercial interior projects throughout this city and Baltimore, and we even did work in this building right here. In the time that I've spent working with Coakley, I've seen many cases of union intimidation, some aimed directly at me, writing on the walls, threats. We were at the Italian embassy and in the 1990s, and a vote came up, and there were guys coming in off the job from the unions, telling me, watch your back and forget what you see, Mr. Cannon, because I was the foreman at the time. I just wanted my guys to go back to work. So, even I felt threatened, much less the workers. And a lot of times the guys, you'll see them, you call them salters on the job, and they'll come in to pretty much upset the balance that you have. There's a lot going on jobs, and it's almost like it's purposely done to disrupt the progress of the job and the production. It makes it harder on everybody. In one case, we were at IBM computer chip plant in Manassas. We had a safety designation for this guy, Mario, and he was supposed to go around strictly addressing safety issues. And in most cases, you don't have the one guy all the time. We have one guy come to the job periodically. But this guy on this particular project was going around getting people to misleading them into signing this, thinking that they were signing, safety, hey, you forgot to sign in the register about fall protection or whatever, when it was really, in fact, signing up for this vote. Back in the, and they were really just using that and they were using the language barrier for me, because I didn't understand what they were saying, and they were kind of twisting the guys, or pushing them towards signing that. That's what I got from that. And as far as intimidations occur, the worst case I've seen was in, we did the VA hospital years ago, where I get to the job. You're always nervous for a new job, and they had made this straw dummy, straw and cloth and paper dummy of one of the foremen, and they had it hanging over the atrium. He was, just a foreman doing his job, and they didn't like the way he did it, and he was scared to death. They also blew his car windows out. They beat up one of the foremen. And there's certain production quotas that are, needed to make do with, make the money. And they weren't very hard. And in one example, as written here, you only need 2,000 square foot of, this says flooring, it should be ceilings. And then that was the quota they were required to make, or at least come close to it. Well, they said, well, Frank, see what you can get. And I, did 3,500 square foot that day in a small areas, which they were doing the hallways, which is a little bit easier, but we were, trying to give them a break. Well, that night, they broke in the gang box. There's lasers and all kind of expensive equipment in these gang boxes. They stole my tools. So the next day when I showed up to work, I didn't have my tools. So I was definitely a little bit intimidated by that, but I got some new tools and went back to work. The writings on the walls when you're doing, in a situation like that, you go into the bathroom or whatever, and they'll say, watch your back. We know where you live. Do it our way, that kind of stuff. So when it comes to a vote, when it gets down to 50% plus one, they're going to, I wasn't intimidated, I did my thing, but they're going to try to get somebody, intimidate them into getting that plus one or two, or maybe even part of the 50. So that's why I would not want this to happen. It would hurt my company, me, a lot of the families that work for the company. And as you mentioned, I think for not to have a vote is un-American. I mean, it's everybody's right to vote on something, and to take that away, it would be, terrible for the American cause. And also what this would do to the other companies, preventing, again, the American dream of companies starting from the beginning, getting bigger, 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 and then having it broken down and being held or kind of shackled by someone else's rules. When they've got to the point that they're at through doing their way of business, then taking on somebody else's way of business would be definitely a hurt to the industry and to the economy as a whole. So hope that was clear, and thank you very much.
Thank you, Mr. Cannon. We're pleased to have all of you here. Mr. Martinez, nice to have you here as well.
Thank you, Mr. Chairman and Senators, for, first of all, conducting these hearings, and second, for allowing me to testify today on the Employee Free Choice Act. My name is Augustine Martinez, and I'm the President and CEO of the United States Hispanic Chamber of Commerce. In that capacity, I represent the interests of almost 3 million Hispanic-owned businesses in this country, generating almost $400 billion in revenue. As you are aware, Hispanic businesses are the fastest growing segment in the small business community. These businesses have many pressing needs, like access to capital, the need for affordable health care, given the steep rise in cost and premiums, and especially the need for comprehensive immigration reform. But one legislative proposal we must avoid is the Employee Free Choice Act. This legislation proposes the most sweeping change in labor law in 70 years, and one that will affect millions of small businesses or worse. It has passed the House of Representatives on a highly partisan vote in February 2007, but was killed with the intervention of senators like you who intervened and filibustered the bill. We commend you for that victory, since it is our opinion and that of the business we represent that this legislation would impose unfair and burdensome costs on businesses of all sizes. The bill contains several provisions that would make it easier for workers to form unions. Under current law, in order for a union to be recognized as a business, 30% of the workers of the business in question must express support for joining a union. This is then followed by a secret ballot where half of the workers must vote in favor of joining. The Employee Free Choice Act would make this election unnecessary and allow unions to be recognized through a process known as card check. A majority of workers simply need to sign cards expressing their intent to join the union, and this process need not be secret. At a business of just 20 workers, you would get 11 people to sign cards in less than a half hour. In the long run, both business owners and employees would suffer. If made law, this bill would boost costs, restrain productivity, and make businesses less competitive. And while some would argue that small businesses are not the target of union organizing, we believe that the cost associated with organizing small businesses is significantly reduced by this legislation. The National Labor Relations Act, which the Employee Free Choice Act amends, applies to retail businesses over $500,000 in sales a year, some products traded over state lines, and not retail businesses with over $50,000 in sales a year. It is safe to say that a $500,000 enterprise these days is not a small business. It's a micro enterprise. Also, due to the lower transportation costs, small businesses are able to trade their products over state lines. Therefore, the net results for this legislation would be a crushing halt to productivity as the small business communities, which is the engine for economic growth, becomes a target of labor organizers' strikes and labor agreements. Small businesses create nearly 80% of all new jobs, much like we produce the vast majority of patents. If we, as a nation, are interested in economic recovery, job creation, and developing the new technologies and industries of the future, the Employee Free Choice Act is a bad starting point. Thank you, Senator.
Well, thank you, Mr. Martinez. Appreciate your comments. We're very happy to have you with us, and we look forward to your testimony.
Can you hear me?
Yes.
Okay. Thank you very much. And Senator Hatch, I'm really glad about your passion for this issue. I share it very much.
Yeah, I come from, I'm one of the few people in Congress who actually earned a union card, went through a formal apprenticeship, and learned a skilled trade. And I have great respect for unions. But this is not right. I don't care what anybody says. And I think a lot of my union friends would say it's not right either. But sorry to interrupt you.
Actually, I'm very glad you did, because I love a politician that'll call a spade, and when it's Orwellian speak, it's Orwellian speak. So thank you for your honesty on that. Excuse me. My name is Kathy Gornick. I'm president of Teal Audio Products. I am also a member of the Consumer Electronics Association, which represents 2,200 of our most innovative technology companies. In order to leave behind poverty and hopelessness and find opportunity to work in freedom, all 4 of my grandparents came on a boat from Yugoslavia through Ellis Island with literally nothing in their possession. As a second-generation American woman, I know firsthand why Europeans left in droves, what they suffered, and how much better they fared here in the United States. And I would like to point out, anecdotally, that it is because of this document that my grandparents came here. They could have gone anywhere in the world, and they came here because of this document. There is not a day that goes by that I am not grateful to them for their courageous act, and it is in their honor that I come to Washington today to testify. Based in Lexington, Kentucky, Teal is one of America's premier loudspeaker manufacturers. We employ 35 people and export our loudspeakers to 30 countries around the world. I co-founded Teal with my life savings in 1977 because I knew that I could build a better loudspeaker. I am profoundly grateful that America let me take my vision and transform it into a business. No other country or system is as friendly to entrepreneurs and risk takers. It is no coincidence that the world's most innovative companies are based in the United States, from semiconductors to computers, From games to internet services, our entrepreneurial culture has made us the world's economic leader. We have succeeded because we are the most creative and innovative nation on the earth, and because our free market system rewards those who work hard, dream big, and take risks. Even in these times of turmoil, all the world looks to America to lead the global economy to a stable economic footing. Unfortunately, a bill you are considering, Senate 560, the ironically named Employee Free Choice Act, would irreparably break our innovative culture, harm existing businesses, and make it infinitely harder for anyone to start a new enterprise. I don't need to tell you why this bill is so harmful. You know that it strips workers of core protections, eliminating their right to a private ballot and allowing organizers to coerce employees into supporting a union. This policy is strikingly un-American. Imagine a presidential election where campaign workers collect cards from citizens in a large public gathering. Perhaps worse, this bill allows government to unilaterally step in and set wages and working conditions if negotiations between the union and the employer become deadlocked. This provision could place the fate of my company in the hands of a government bureaucrat who may have no knowledge of my industry or the competitive circumstances in which I operate. But as bad as this is for business generally, card check is especially pernicious for the technology industry. Over the last 2 decades, high tech has emerged as the engine of the new American economy. As traditional manufacturing has struggled, American high-tech companies have produced world-leading products and services in the face of challenging market conditions. The consumer electronics industry alone now contributes more than $1 trillion a year to the economy and supports 15 million jobs. Tech employers attract the best and the brightest, and they pay well. The average technology worker made $78,035 last year, a 4.6% increase from 2007. Today, we make up the most dynamically and rapidly evolving industry in economic history. A tech firm must be innovative and nimble, or it will not survive. Our work environment is fluid and flexible, with firms constantly adjusting product lines and job duties in response to new threats and opportunities. Now, imagine a technology company forced to operate under the auspices of card check. Within 120 days of a coerced union election, a government bureaucrat could unilaterally determine the most elemental working conditions for the entire workforce. Not just wages, but job descriptions, the number of allowable bathroom breaks, and what sort of products we could make. Firms that could have otherwise adapted to meet new engineering and marketplace challenges would be handcuffed, forcing them down the familiar path of restructuring and mass layoffs. The clear message to American companies would be that if they want the freedom to innovate, they should look overseas. These concerns are not merely theoretical. For a real-world snapshot of the impact the card check would have on the American economy, look no further than Detroit. No matter what innovative business plans auto manufacturers devise to turn around their industry, rigid union structures stand as a virtually immovable obstacle to change. That is why card check may grow the number of union members in this country, but it would not grow the number of jobs. One economic study projects that card check would add a full percentage point to our nation's unemployment rate. That's 1.6 million more Americans losing their jobs. As an entrepreneur and a proud American, I implore you to reject this ruinous proposal. Card check would be a disaster for the economy and for innovation. In the current recession, adopting a backward-looking industrial policy that stifles innovation and piles costs on business is simply beyond folly. Please say no to card check and focus on reasonable proposals that would support entrepreneurs, grow jobs, and get America moving again. Thank you, and I'm glad to take your questions.
Thank you, sir.
Seemed to me to just run counter to the things that we ought to be doing right now and focusing on, which is trying to figure out ways to get small businesses creating jobs again. So I thank all of our panelists for their excellent testimony and willingness to be here today and to share some of their perspectives and insights about how this particular piece of legislation would impact our economy. And I would simply note that it's referred to, as are many bills around here, they give them great titles, Employee Free Choice Act. I would argue it's the Employee No Choice Act. And I think that bottom line is, even though it's being billed as something that's good for working people, I think it's very anti-worker. It deprives people in the workplace of an opportunity to cast a secret ballot in a union election. And in my judgment, at least, we are, as members of Congress, elected by secret ballot, and I can't believe that we would want to take away that right to workers across this country. So I appreciate your willingness to speak out on this. I think it's really important that we hear from people who are impacted by this in a real world way, because you know, we tend to have these policy debates here in Washington, but when you look at not only the fact that this denies the secret ballot to workers in this country, but also the impact, as you've noted, that it has on jobs. This is a job killer for our economy. It's something that would be absolutely disastrous, I think, and so I'm hoping that there will be enough people around this country who will rally to this issue, recognize the harm that it would do to the economy, and would help us get the votes in the United States Senate to defeat it. I will say that it has generated interesting opinions from different people around the country. I had a meeting with some business leaders in my state of South Dakota last week, and which was very useful and enlightening, because most of them are small businesses, just to hear about some of their experiences and how they view this legislation impacting them and their ability to create jobs. But we also have a former senator and presidential candidate from my state, George McGovern, who has been a friend to organized labor his entire career, and someone who's certainly not been in opposition to many of the policies that organized labor would consider to be beneficial, who's come out and said that it would be wrong to take away the secret ballot in union elections. So, Mr. Chairman, thank you for inviting this very distinguished group of panelists, and when the time comes, I have a couple questions I'd like to ask of them, but I certainly appreciate your holding this hearing today. Thank you.
Why don't you go ahead and ask your questions now? You be our first questioner.
Well, I would like to direct a question to Mr. Scalia, if I might, and that has to do with the fact that not only does this do away with the secret ballot, but it also creates the system of binding arbitration. And my understanding is that companies can use arbitration currently as a way to settle disputes with customers, other companies, and even current labor employer relations. In some cases, this can help companies, and others avoid the costs and delays of litigation. Can you elaborate, though, on how this binding arbitration provision is different, and why these provisions would harm workers and employers' rights?
Yes, I'd be happy to, Senator. Arbitration of the type that you described can be a valuable thing. It can be a way for parties to submit by agreement a dispute that they have to a knowledgeable individual of their own choosing, rather than to a court. They can save court fees, litigation costs, and the like. And that arbitrator takes an existing contract and explains what those provisions mean. But what the interest arbitration provision in this bill would do, it would be that an arbitrator, instead of interpreting an existing contract, would actually be deputized to sit down and write a contract for the parties from the first instance. It would be as if we used our courts not to interpret the laws that this body enacts, but instead we use them to sit down, take pen to paper, and write the laws that they thought were best. They don't have the qualification to do that, nor does an arbitrator have the qualification to determine the rules that should be set in the first instance to regulate a business. That's what this bill would do.
Mr. Martinez, I appreciate your leadership with Hispanic Chamber of Commerce, and one of the points that's made about this legislation is that it would, it's been argued, I should say, that minority workers would benefit from this legislation. I guess I'm just curious to know, based on your experience, do you believe that is a true statement?
Well, again, thank you, Senator. Again, representing 3.5 million Hispanic small businesses, we think that this truly is, as you said, a job killer for our community in certain instances. what we find is that there are our small businesses are challenged in so many different ways right now to be able to, or at least to be confronted with this type of legislation right now, when the real need right now is access to capital and affordable health care, and traditionally the small businesses, and in particular Hispanic small businesses, are the people who are actually creating jobs in our communities. And to have something like this and to take away their ability to go ahead and weigh some other matters that are more important to their small businesses is disappointing at best.
I'd just like to, if I might, direct a question to all of our panelists, and feel free to answer it. But you probably have heard there's been some talk lately about a possible compromise on this legislation. And I guess my question is there such a thing as compromise on this legislation? In other words, can it be rewritten in a way that would allow workers to vote their conscience in secret? I mean, is there a, in your estimation and judgment,
No.
Ms. Gornick? Okay, that's definitive.
Could you be more direct?
Anybody else care to comment on that? I mean, this potential for compromise.
I think, Senator, we feel very, very strongly as well, but we haven't seen what's been out there. So I would hate to advocate or be positive and just say no, but I think that we'd have to see it in order to make a decision on it.
Yeah. Anyone else? Mr. Scalia?
As has been said, the bill that's before us is the Employee Free Choice Act, which certainly is very problematic, and I would say it's a compromise. It compromises fundamental rights to vote, fundamental rights to property. I would also add, though, that before any labor reform is made, it's obviously going to be important for members of this body and the House, the President, to take stock of the effects that even minor adjustments could have on our economy. There's been a lot of literature by professors and others suggesting that labor unions have been harmed by the existing labor organization rules. I think when you look at that literature, unions have not made a compelling case that there is extensive employer illegality under existing law. I think instead what's going on is that unions have imposed often crippling contracts on companies. Those companies have declined. Unions have declined with them. And I think it will hurt, not help unions in the long run if we have labor laws that impose even greater costs on American business.
Thank you, Mr. Chairman. I guess I concur with the panelists that the best thing to do is defeat this. I don't see a potential there to compromise, at least based on any of the discussion that I've heard to date. It seems to me this is a pretty straightforward issue. So thank you. Thank our panelists.
Senator Risch, why don't we go to you next?
Mr. Scalia, Idaho, the state I represent, is a right-to-work state. And we got there only after a lot of debate, a lot of serious soul-searching. A bill was passed in the legislature. It was vetoed. It was overridden. The unions then took it to a referendum, all of which gave the matter a very good airing. In the end, the voters, by a wide margin, agreed to the law that the legislature passed, and that is allowing a worker to either join or not join a union as he or she sees fit. The question I have for you is this. After all this work that the state put in it, and after all the emaciations they went through, what effect will the bill, will this particular bill have on the 20-some states that are right-to-work states?
This bill would apply in right-to-work states in just the same way that it would apply everywhere else. So it may be that some workers in right-to-work states feel that, well, I'm in a right-to-work state. I've got some extra independence and protections as a result of that. But it's one of the unique features of our federal labor laws that they have very powerful effects within the states. They preempt state laws. Our labor laws do allow right-to-work laws, but they don't exempt them from things like what we would have here, which is elimination of the secret ballot and interest arbitration, and very expensive penalties too, by the way, which also are provided for in this bill. So I guess, Senator, to put it briefly, every ill effect of this bill that you've heard about this afternoon would be felt equally in a right-to-work state.
I guess one of the things that struck me after listening to your testimony and the other testimony here was that in states that have people that have an independent streak, if you would, like Idahoans do and some other states, people want the ability to work for an employer, to negotiate with the employer on their own abilities versus having a collective bargaining. After this passes, as I read the bill, a person who has opted out, has taken advantage of a state's right-to-work status, has opted out of the union, is now going to be bound by a federal negotiator, and I guess not negotiator, but arbitrator, that would come in and make decisions for them. Is that how you read the bill?
Yes, Senator. And if I could refer to a brief that was filed by the AFL-CIO and Change to Win Coalition in a Supreme Court case this term. The AFL-CIO and Change to Win Coalition said in their Supreme Court brief, they said, labor unions have a self-interest of their own. And they said, and I'll quote them, they said, sometimes there's, quote, a direct conflict of interests with respect to an employee's choice, a direct conflict of interest with respect to an employee's choice, end quote. That's what the AFL-CIO said about how sometimes there is a real conflict of interest between unions and workers. Unions can do very valuable things in some workplaces. Some workplaces need to be organized because the employers are not behaving responsibly. But that ought to be employees' choice. There is a conflict of interest between unions and employees when it comes to organization. And specifically with respect to what happens in a right-to-work state when you do have this contract written by an arbitrator who may not even know the company. That's right, it would bind the workers at that company, even if they were not forced to be a member of the union itself. They would still be covered by that contract and not able to negotiate for themselves.
So in short, what the bill does as written, it essentially abolishes that portion of right to work that allows an individual to do as they choose in their negotiations or their relationship with their employer. Is that a fair statement?
What I would say is that as it would in any other state, it puts employees in a position where they may never be able to get to vote on whether there's a union, and they may never get to vote on the contract that's imposed by an arbitrator. And yes, they would not have an ability anymore to go to the company themselves and say, hey, I want to talk to you about the terms and conditions of my employment. I think I'm entitled to more pay.
Thank you very much. Thank you, Mr. Chairman.
Thank you, Senator. Let me turn to our Policy Committee Chairman, Senator Ensign, for any comments or questions he might have.
Well, thank you very much, and I think this is a very, very important hearing, obviously, for an issue of incredible import to the United States business community as well as to employees. Let's say from the outset, I think that we all need to agree that the labor movement has done a lot of positive things for workers in America. There was a time where management really abused employees. Today's globally competitive marketplace has shown, though, that management needs flexibility. There's no question that as the marketplace has become more competitive, whether you have a union or not is not as relevant today as it was, simply because to keep competitive, you need to treat your employees well today. You cannot afford to treat employees the way that they used to treat them. Now, the labor movement in the United States has gone all over the world to argue for the secret ballot, just as it argued for the secret ballot here in America. And why did they do that? Why do we have a secret ballot, whether it comes to electing a school board, a county commissioner, a governor, member of Congress, or president, and the same reason we had it for electing whether we are going to have our workplace unionized or not? The reason we had a secret ballot is so that people could, of their own free conscience, vote how they wanted to vote, free of intimidation. If the secret ballot is taken away, that intimidation, whether it's from management or from labor, can take place. It seems to me that when the advantage was for management to intimidate, labor didn't want that, so they argued for the secret ballot, which they have done in country after country after country around the world. And now, labor is in a position to intimidate and get what they want, and so they want to eliminate the right to a secret ballot. They want a 50% plus one of the employees to sign a card. We've had a lot of experience with that in my hometown of Las Vegas, and if this does pass, there's no way to stop a company from being organized. There's absolutely no way to stop it because of the intimidation factor. So this legislation, opposing this legislation, I think is critical, one, for the competitiveness of the United States, and just because it's the right thing to do. It is the right thing to do to preserve the right to a secret ballot. As far as questions concerned, if any of you would take us through how exactly today, because the argument from labor has been that there's a balance or a lack of balance in the organizing process. In other words, they say that the advantage is on management's side. If you talk to management, they say it's on labor side. But having said that, let's at least go to the facts. Can somebody walk us through exactly how, from the start, if employees want to organize, what are the steps that occur today? Mr. Scalia, would you like
yes,
to try?
I can take a first crack at answering that. One thing it's important to be clear about at the outset is that a drive to establish a union in a particular workplace is not ordinarily started by the employees in the workplace. I think a lot of people have an image that what happens is the employees, like in a Hollywood movie, up and decide all by themselves they want a union, and that it's a grassroots movement internal to the company. That happens sometimes, but labor unions are very sophisticated enterprises that have on staff a number of people. They call them organizers. Their job is to go out and organize a workplace. As I think Mr. Cannon may have mentioned, unions also employ what are called salts, people that they get to go out and work for a company, get hired by the company, so that they then can set about organizing the company. The process that's followed is one where, and this would be even more so under the Employee Free Choice Act, where the organizers and employees within the workplace whom they find to be sympathetic get together and meet with other individual employees that they would like to support them. They present them cards to sign. They're called authorization cards. Quite often now, statements are made along the lines of, just sign it, it means you'll get a vote. Doesn't mean you necessarily want a union, it just means we're going to have an election. The cards, it's a form of voting under the Employee Free Choice Act. It would be like voting, except now the election supervisor is the candidate. It's the union organizer. And one of my concerns is that the circumstances would be, for example, an employee's in the local store on the weekend and gets surrounded by 3 or 4 coworkers who say, hey, are you with us or against us?
Before you argue for or against, just let's lay the facts out. What percentage of the employees have to sign those cards before it then goes to the next step?
Right now, if 30% sign the card, then they can petition for a secret ballot election. You can have an election conducted.
And then how long of a process is that?
Not long. It's actually, for a lawyer, one of the quicker moving processes. There can be a hearing within 2 or 3 weeks to make sure that you're looking at a proper group of employees to organize. And on average, these elections are occurring within 50 to 60 days of the time the petition's filed. That's the time that those cards are filed. So 90% of elections are occurring within that period of time. It's a fast process for the election.
Okay, and then what happens after that?
The votes are counted. And when you talk about...
During the process, when they sign the cards to the election, what happens during that period?
Until the cards are submitted, there's been an attempt to keep the employer from knowing. And typically, once the cards are submitted and the petition's filed, there's notice now from the Labor Relations Board Now the company knows, oh, wow, there's an organizing campaign. They may have learned before. The aim is to prevent them from knowing. So there's been a union campaign for a long time. Now the company campaign can start. What does the company do? They talk to employees. They will hold meetings on the company premises and express their views. This is free speech. And of course, the union also will be contacting employees. The union is not able to have meetings on company premises, but it can go to people's homes. As I mentioned, it can contact them on social occasions. So there are different forms for the different, in a sense, candidates to contact people.
Okay, and then there's a secret ballot, and if the union wins, what happens?
If the union wins, the votes are counted and certified by the National Labor Relations Board. Again, it's overseen by federal authorities. They bring in ballot box or certain restrictions on getting too close to the voting. It's secret. And when you talk about balance between the company and the union, one thing it's important to understand is one real disadvantage for a company is if it believes that there's been a problem in how the election was run, it still has to bargain with the union and can't immediately go to court. It's very, very hard, nearly impossible to immediately go to court. So that's one example where you'd say, wow, that's a hard thing for the employer. You'd think that if they thought the election was wrong and they shouldn't have to bargain with the union, they could raise the issue right away, but generally they can't.
Just one comment and then turn it over back to you, Mr. Chairman, is that obviously we shouldn't legislate by anecdote, but a lot of this is anecdotal. A lot of us have different experiences. I had a guy I've gotten to know over the last several years. He was telling me about an organizing attempt at his company, and they got 30% of the employees to sign the cards, so they went through the process. And when it came to the secret ballot, they had about 100 employees working. Only one person voted to organize. And so he went to his employees and he said, why did you sign the cards? And they said, well, you have no idea the intimidation that takes place. We signed the cards just to basically get them off our backs. But they obviously, based on their secret ballot, they thought that they were being treated well by their employer, and they didn't want to have a union represent them at that point. So it's just another one of those stories that why, the card is a public thing where intimidation can take place, where the secret ballot is a private thing and nobody knows how you're voting. And that's why the secret ballot is such an important thing to keep intact when we're going forward as Americans. Thank you.
Thank you, Senator. Ms. Gornick, if EFCA passes, the Employee Free Choice Act passes, what's going to happen to your company?
It's rather terrifying to contemplate what would happen to my company. One would hope that my employees would completely reject outright any kind of intimidation, but I don't know because I can't imagine, for all the reasons that people have mentioned here, that they are human beings susceptible to the same feelings with their coworkers and are susceptible to intimidation. So if it went through, especially in technology companies, I think this is really a disaster. The technology companies are asked to react more rapidly, I think, than virtually any other sector of our economy. This is not, going back to the great industrial revolution where you could just sort of make the same widget on the same machine for your life. Things are happening at such a rapid pace, and that rate is actually increasing. So the ability to be flexible, and I am talking sometimes on the order of weeks, where some new, very, very, what you would call a creative destruction of the marketplace occurs. Some new technology comes along, and you are all of a sudden irrelevant. And you had better act very, very quickly to adapt to what the consumers want. So you start doing things. You change job descriptions. You start hiring different kinds of people. You alter your entire plan for your company. The thought of a government bureaucrat coming in to tell me how to do that, or a union, it's like oil and water. We would probably have to go out of business because we would be too small to actually fight it, to know, right now, especially in this economy, we're having a hard time keeping our nose above water, doing everything possible, humanly possible to, stay in the black and hang on until this economy turns around.
What would you do if your company was unionized through card check and you couldn't get a collective bargaining agreement within 4 months, and a federal arbitrator comes into your workplace and begins dictating wages, benefits, terms, and conditions of employment? What would that do to your company, and what would you do?
I think I would try for a little while, probably, because people who know me know I try things and I'm not a quitter, and most entrepreneurs are not. Most entrepreneurs will do just about anything that they can to survive. But I think I would be extraordinarily demoralized because it is so touch and go right now that I cannot imagine the decisions that I would have to make could happen quickly enough for me to be able to stay afloat, especially because we're so bound up in the global economy and there's all that Buy American stuff going on in the, I don't know, there's the attitudes that come, I would think, with a government person that would inherently sort of either, at best, just not get what we do. I think they would be pretty clueless, and at worst may feel that some of the stuff that my company does, because we're so globally interconnected, we both buy and sell around the whole world, they might not even like that and may even attempt to switch us to a different, orientation. So I feel pretty sure I'd go under, but I would go down kicking and screaming.
These are high-paying jobs that you have. On the average.
I'm sorry?
These are high-paying jobs that you have. On the
Well, in fact, they are. I have to, many years ago, we had, unbeknownst to me, a union organizer came in, and I only found out after the fact because this person held a meeting, and of course I know that by law that is allowable, and what came back to me through my own employees, they told this guy that they thought that the union had nothing to offer them because things were so great at my company. They liked the small family atmosphere that we have. They were very well paid, and actually, Senator Ensign, what you said is exactly right. And by the way, thanks for being from such a great state where the Consumer Electronics Show is. We just love it. It's the greatest show on earth, by the way. You all should come. But that the employees should, the employees really have much more of a level playing field than anybody could imagine. It is so competitive out there. We are, like our little company, as soon as 401ks came along, we had to dive in and get those. We have to have medical insurance. We've got to pay way above minimum wage. So, and then these people say, well, I got a better job offer, and I'm going, okay, what can I do? I'll do anything to keep you. So, I just don't, I think that the whole card check is a solution looking for a problem. And it's very, very onerous. It's like a wedge that would come between me and my employees. And furthermore, I think the fact that unions, are so, I don't know how come they get away with proposing such terrible legislation without being shamefaced about it. It is so, to me, about them and their coffers and their numbers. They don't really care about the jobs of their members, because if they did, they would not support this legislation. This legislation is going to destroy jobs, and it's going to increase the coffers of the unions, in my opinion.
Mr. Scalia, let's assume that the card check bill passes and a company gets 50% plus one to sign a card. They automatically are certified unionized, right?
That's right.
Okay, and then let's go a little bit farther there. Do you think it's likely in the next 4 months that there will be a collective bargaining agreement between the two parties?
Not a good one, Senator.
Very likely, is it?
I think it's very unlikely. It typically takes longer than that to reach an agreement. As you mentioned in your remarks, a collective bargaining agreement tends to cover a lot of subjects. That's what unions want. It takes time to go through all those, particularly in a new contract. And one of the concerns that people who've been in negotiations have is that once a union knows that ultimately an arbitrator, that it may have some role in selecting, is going to have the ability to cram down terms, the union might be even more difficult to work with during the negotiation period, and it might really just be playing ultimately for the arbitrator rather than trying to reach agreement during that short
If they
period.
roll the dice, they're likely to come out better with the arbitrator than they are by coming up with a collective bargaining agreement. But even if that isn't so, that's the average collective bargaining period is more than 4 months, isn't it?
It is. I believe so.
Well, okay, so then the federal arbitrator comes in, right? And he or she sets the, like I say, the terms, benefits, conditions, wages, conditions of employment, all of that. For how long?
It's for 2 years.
Can anybody change that?
Pardon?
Can anybody change that under the law, under the card check bill?
If the parties themselves agree to change it, they can change it, but that's going to be extremely unlikely. It's going to be in place for 2 years. And one of the things that troubles me about this bill is it's not clear that there's any ability to go to court and say, Your Honor, the arbitrator wrote this new business plan for me. It doesn't work. It's confiscatory. And I need you to review it. There's no clear opportunity to do that. It's not clear what standards the arbitrator or the court would apply. That raises constitutional questions, actually.
Sure. Mr. Cannon, I want to turn to Senator Thune. Mr. Cannon, now you mentioned this process of salting. Could you define that for us? And have you had salting in your non-union business? As I understand it, you did a lot of the drywall right here in the Dirksen building.
I personally didn't work in this
No, but
building,
your
but our
company,
company did.
Yeah.
Well, they're called salters, and they're kind of hard to pin down or prove, but in the past, they've come from the unions and attempt to organize or, get signatures for this card check.
From within the company?
From within the company. And I think that's what happened when we were at IBM. That's the safety guy was going around under the guise of, the safety program and getting these signatures, and that's what got us to the vote. And they intentionally disrupt and gather these names for the purpose of organizing.
Did any of them threaten you?
Writing stuff on the walls. Hey, Frank, we know where you live. How's your family doing? Stuff like that.
Senator Thune?
Thank you, Mr. Chairman. Mr. Scalia, you were the solicitor of labor, which I presume means that you enforced the Landrum-Griffin Act of 1959 as a lawyer there. And I guess my question has to do with my understanding is that statute requires a secret ballot for union officer elections. And I guess my question is, are you aware of the reason why you would require a secret ballot and why it would be more important to have a secret ballot for union officer elections than union organizing elections?
Senator Thune, yes, I did have responsibility for enforcing that act. And the reason it's important in the union election is because otherwise there will be pressure by the candidates. But of course, that's the same reason that it's important in the election as to whether or not to have a union in the first place. And one of the things people need to remember, I talked about union organizers. These are people really whose livelihood depends on persuading people to decide to form a union so there are more dues available to pay their salaries and the like. So we ought to have it under both statutes for those reasons.
But it is statutory that a union officer has to be elected by a secret ballot.
I believe that's correct, yes, and the Supreme Court has noted that.
Thank you, Mr. Chairman.
Could you walk us through, under the legislation, if employees want to decertify, they don't want to unionize anymore, what would happen at that point? Are they allowed to just have a card check, with 50% of their employees plus one say we don't want a union anymore? Would that fly under this legislation?
No, Senator Ensign. I believe a couple of members of Congress have suggested that that's true, that there can be decertification with card check already. But no, decertification requires a secret ballot election. That's one of the interesting things about this statute is the same part of the National Labor Relations Act that says secret ballot election to form a union. It's the same part of the statute that says secret ballot election to decertify. So they want to come in and make a lopsided change to leave secret ballot to decertify, but to take away the right to certify.
I think that's a interesting observation because, people have argued, why do you have a secret ballot in the first place? And it's the intimidation factor. Mr. Martinez, you are out there in the business world. You talk to business people all the time, and this intimidation factor that folks are afraid of for your employees, for the whole workplace, that is something that people want to keep out of the workplace, is the intimidation factor. Has that been your experience?
That's exactly right, Senator. And again, you're talking about a very, very large Hispanic community, which in most cases tends to understand there may be some intimidation there. So you're always worried about predatory practices in terms of coercion and various other things when it comes to collective bargaining.
Very good. And just one last question. During the election process, my recollection is that to avoid a union, management is not allowed to promise things to avoid, but outside of the walls, what are unions allowed to promise?
They can promise the same kinds of things politicians do, Senator, and it's okay. And I mean that with all respect.
That's the point. That's the point, though, is that unions can promise things, but management cannot promise.
That's right. You asked about balance in the process, and that's an instance where the statute takes away an ability during a campaign to do what one ordinarily does.
Thank you, Mr. Chairman.
Well, I want to thank this excellent panel. Look, it's hard for me to understand how anybody could, with a straight face, advocate this type of legislation. I think people ought to have a right to unionize, but our laws protect their rights in almost every way. I think every way. And in all honesty, to take away the secret ballot, and that isn't, to me, that's not the worst part of the bill. I think the worst part of the bill is mandatory arbitration, where they set the wages, terms, benefits, and conditions of employment. Somebody who might not even understand even the basic principles of that particular business. That's a tough situation. But you've all helped us to understand this better, and we're very grateful for you taking this kind of time and coming and being with us. So your time hasn't been wasted. It's a good thing. And I do believe most members realize that if it wasn't for the political power of the national unions, this wouldn't even have a chance. But they are powerful and have a right to be powerful, but not to put forth legislation like this that really has no constitutional justification whatsoever in my book, and I think most people would agree with that. And as I said at the beginning, 74% of unit households agree that we don't want to do away with secret ballot elections. But thank you so much. With that, we'll recess until further notice.
Great.